Well, thank you, Rich, and it's really a pleasure for me to be here. A pleasure to share with you in a few words the experience on the Council of Europe, but also a pleasure to benefit from all the discussion that will take place today and in the next 2 days on issue of really common concern. So the Council of Europe, is that working? Yeah, I have to synchronize my computer and the screen, and it's a multitask issue. So the Council of Europe, briefly, and you can have more information on the website, is an intergovernmental organization set up in 1949. It's composed at the moment of 47 member states, European states. The only exception would be Belarus. And the objective of this organization is mainly the protection of human rights, promotion of democracy, and rule of law. And the Council of Europe has been active in the field of bioethics since the late 70s. The objective of this activity is clearly linked to the protection of human rights objective of the organization in the particular field of biomedicine. And a major step was achieved in this work in 1997 with the opening for signature of the Convention on Human Rights and Biomedicine. But before that, the Council of Europe has been elaborating a certain number of legal instruments which were not binding. So why suddenly going from non-binding instrument on specific topics to legally binding ones? Well, it was felt at the beginning of the 90s that there was a lot of great diversity of national law in the member states addressing some of those issues related to human rights and biomedicine. And there was a lot of new development, just to mention, for example, in the field of transplantations, of genetics, that raised a certain number of concerns with regard to those values which the Council of Europe aimed at protecting. And that mere declarations of guidance was not sufficient anymore to protect those values, and it was important to establish fundamental principles in a legally binding instrument that could also be introduced into national law to ensure that those values are really protected. The Convention on Human Rights and Biomedicine, also called Oviedo because it was open for signature in Oviedo, Spain, is the first and, to my knowledge, only legally binding instrument in that field at international level. It has a framework conventions which contain provision applying to daily medical practice, and as such is also known as the European Patient Treaty, but also has some provisions addressing specific fields, and it reflects actually the recent development I was referring to. Those specific fields are transplantation, genetics, and biomedical research. It has become now reference value at national as well as international level and has a lot of impact both on practices and national legislations. I think it's worth noticing in this context that even though those principles were elaborated in the 90s, when the text was re-examined in 2005, the member state did not feel that it was important to change those principles in the light of new development, and there was no revision of the text undertaken in this context. However, the elaboration of that convention was not without difficulties. First difficulties, elaborating legally binding provisions addressing a field which is constantly evolving. That is a real challenge, especially when you try to get agreement at 47 member states. Other difficulty, cultural differences. Just give you an example, what the notion of family, how it's perceived. Autonomy versus social norms. All these elements create lots of discussions between the different member states of the Council of Europe at that time. And also some of the issues which were addressed in this context were particularly sensitive. I'll give you two examples. Research on persons not able to consent for historical reason, I think I don't need to explain, and the research carried out during the Second World War. It was a very sensitive point. And the embryo remain a very difficult issue on which at the moment it's extremely difficult to get agreement, and I think it will be like that for quite a while still. However, there was a political willingness to agree on those fundamental principles and on the need for legally binding instruments addressing those issues. The convention has since then been complemented by additional protocol focusing on one particular, on specific field. These protocols were foreseen at the time the convention was elaborated, with one exception, the one on cloning. The protocol on cloning was not foreseen. For what reason, nobody was expecting Dolly to appear suddenly, and biological dogma were completely abandoned, or at least affected by this birth. And that was the same at international level, talking about bioethics. But the point I want to make is that despite of this difficulty regarding the embryo, there was such a concern and common concern about the implication of that development for human rights, and such political willingness to achieve something at international level which will prohibit human cloning, that this protocol was elaborated in 6 months after the announcement of Dolly, the birth of Dolly. And I think it's worth notice in this context. Now, this convention is indeed a regional instrument. It represents a European consensus, but it addresses issues which are faced by countries outside Europe. It takes also into consideration the international dimension of the issue addressed. And it's based on values, I don't dare to use that word now, but based on values recognized and shared outside the 47 member states. Well, it may be argued that the cooperation mechanism, which was already in place in the Council of Europe, was a privileged framework to achieve that result. And maybe it's difficult to find the same type of framework at global level. However, I leave that as a question for the next two speakers, but also for the discussions, as to whether a regional initiative can be used as a possible basis for a global one. Now, the last point I wanted to make, because I think those are extremely important elements to understand and to understand the success of this initiative, but also an element which actually is a main feature in this success. It's the cooperation mechanism in the Council of Europe. Cooperation with non-member states, and that includes the United States, but also Australia, Canada, Israel, Japan, and Mexico, as far as the observer states in the Council of Europe are concerned. They are very actively participating in the activities, and they are very actively participating, in particular, in the activity in the field of bioethics. And I just give the example of biobanks, because we've been working on this in 2006, and we'll be doing it again this year and next year. And we have a common concern about the issue raised by this development, and the international dimension of the phenomena cannot be rejected. Cooperation also with the civil society. And that's an integral part of the Council of Europe activities. And outside the bioethics, and I will come back on bioethics within 55 seconds, the Council of Europe is actually promoting the civil society participation in decision-making process at national level, and has adopted, and the Conference of NGOs, which has been set up by the Council of Europe, has adopted a code of practice to promote that participation at national level. But it's even more important, I would say, in bioethics, where the issue we are addressing concerns all citizens. And we achieve that, we ensure that cooperation through a different process. We organize hearings, we have public consultation on preliminary draft instrument, legal instrument. But the citizenship participation, citizen participation in the discussion is also promoted as such by the Convention in its Article 28. And we're trying to contribute to that in the Council of Europe by trying to promote discussions among citizens, in particular young people, as was mentioned by Richard. So I will stop here for so much sharing about the experience of the Council of Europe. Thank you.